Part of the Dodd-Frank financial regulation overhaul. The federal government plans to reward company insiders and other tipsters for blowing the whistle on corporate fraud. And the SEC is scheduled to vote on Wednesday on a far-reaching proposal to do just this by paying these private employees to join the fight. Now, as you may or may not know, the government already pays money to whistleblowers for exposing tax evasion fraud or Medicare scams, Pentagon procurement abuses. And so the SEC is going to vote on Wednesday to extend this type of program to financial fraud, to corporate fraud, and the corporations are really pissed about it. This is one of the funniest things I think I've read in a long time. Businesses say that before whistleblowers share information with the SEC, they should alert the company they are accusing and give the company a chance to address the alleged misconduct. That is wonderful. Some business groups say they are worried that the SEC could be overwhelmed with tips. And they say they want to ease the burden on regulators by screening the complaints. How wonderful. How nice. God. And they say business is just in it for the profit. Here you have these wonderful business leaders who are so concerned that if the SEC pays tipsters, pays whistleblowers money, that they could be overwhelmed, and businesses just want to help them out by sort of taking off some of that caseload. That's fantastic. You know, the mafia should have thought of this too. We don't want to overtax the police services. We want people to we want the cops to be able to be on the street and help old ladies cross the street. So what we're going to do is, if you get a guy who is an informant, have him come to us first. We'll see if it's worthy of your time. And if it's not, we'll just tell the guy to take a vacation somewhere. You won't hear from him again. This is fantastic. Companies are far better equipped to assess complaints in the context of their particular business and to separate the wheat from the chaff, said two major Wall Street groups, the financial services. This is hilarious. I mean, how embarrassed would you be to be the spokesperson for this and just get out there and just say, look, nobody knows better how to evaluate whether or not a whistleblower is telling the truth or knows what he's talking about, that we're up to wrongdoing, than we do. We're doing the wrongdoing. We should know. So basically what they're trying to do is they're trying to insert mitigating factors into this regulation that would pay whistleblowers. And it includes one measure that would prevent scorned husband or wives from cashing in on secrets. Husbands, really? Really? What they're afraid of is some of these douchebags who are going and doing blow on the nipples of strippers at bars are going to talk too much to their wives about their financial corner cutting. And then when it comes time for the divorce, they're going to get screwed. So we can't have that. You can't pay husbands or wives any money. And the Society of Corporate Secretaries and Governance Professionals, whose members play supporting roles for executive and board members, say whistleblowers should not be allowed to profit from information gained through the violation of any privileged information, such as spouses, or perhaps secretaries, or executive assistants, or anybody who would be in a position to actually blow the whistle. Number two, although the law prohibits companies from retaliating against employees for blowing the whistle, The corporate secretaries group asked the SEC to make it clear that companies could still fire whistleblowers for other reasons. Yes, granted, you went to the SEC and told them that we're involved in massive fraud, but we don't like the way you dress, and we can't fire you for blowing the whistle on us, but maybe you shouldn't be wearing those red-colored shoes. You're fired. Number 3, a third proposed change would prohibit lawyers from representing whistleblowers for contingency fees. In other words, if we can get the trial lawyers out of the equation who represent whistleblowers and classes who may be defrauded by the information whistleblowers provide, then we can make it virtually impossible for them to get a lawyer to represent them. This is the same thing we saw the Supreme Court rule in a 5-4 split a couple of weeks ago on not allowing for arbitration claimants to form a class so that they could be represented by one attorney rather than 5,000 of them who are going after $30 be represented by 5,000 attorneys. This is just wonderful. Well, good luck with that, corporations. I'd be shocked if the SEC actually carries out this mandate from Dodd-Frank, but I hope they do.